versus Joshua Mackey. If I could have parties re-announced, please.
Defendant for the state of Texas.
And Kelly Fiddle for Joshua Mackey.
All right. And this is a continuation of the hearing that was started this morning. State, any witnesses?
Fortunately, it's not having markers.
All right, defense, any witnesses?
Defense rest, Judge.
All right, the court has found violation of condition number 5 true. The court is going to find violation of condition number 1 not true. The court is going to find 15 FF not true. All right, any objection to the court reviewing the court summary?
None from the state.
Can I see it?
And for the record, the court has not reviewed the court summary.
Can I remove the violation reports?
You'll have to speak with probation about it because that's their court summary.
I just don't, I have no problem with you speaking to the court summary, but not the violation reports since they were not. Okay, that's right. No objection, Judge.
Oh,
so
you have your own? Sorry.
No, I don't.
oh, okay, then, yeah, that's, yes.
All right, so what portion are you all asking me not to read?
Yeah, I didn't realize that the violation reports are already in the court's file that you,
Yes.
that's taken judicial notice of, so no objection, Judge.
Okay.
And if we could just have time for a brief argument after.
Yes. Oh, and counsel, I don't have a trial court certification.
We'll get you one, Judge.
Okay. Oh, do you want to grab that while I read this?
Sure.
Sure.
And state defense and Mr. Mackey, I see that there's a condition of number 1 in here. I previously said that that condition is not true.
Yes, Your Honor.
So I'm not going to consider that because I found it not true. And it's the same dimension of condition 15 FF. I've also found that not true.
Thank you, Judge.
Okay.
Judge, can I present to support?
Yes.
I'll have it marked if you would leave it to. The state has waived this condition 10D, but I just wanted to bring it to the court's attention that the restitution is paid in full.
So was the restitution 36,000 or was it 44,775?
It was, what he owed was the 4,000 number.
Okay.
The total was the 36. The 4,000 was paid.
All right, the court has reviewed the court summary and the court has reviewed the document that the defense asked the court to review. State, what are you requesting?
Your Honor, you've taken judicial notice of the entire court file. You're aware of the facts of this case, the egregious nature of them, involving shooting the victim through the head, the right temple, exiting out the left side of her face. Very well could have killed her. Thank God it didn't. Otherwise, we'd be here on a different charge. So given the facts of the case, given that the defendant is on his second MTR since he had been placed on probation, and given the one true violation you found, Your Honor, state would ask for him to be revoked, adjudicated guilty, and sentenced to 10 years TDC.
All right, just one moment. I'm just trying to find in the court's file, I'm trying to find the admonishments page. Client be sentenced to 10 years in the prison. What are
Judge-
you requesting?
Judge, we're asking that you deny the MTR and terminate his probation. In regards to the facts of the original case, I believe I represented him at the time of his plea, and the complainant was okay with him getting probation. Judge Hilbig gave him probation, gave him jail time as a condition. In between when Mr. Mackey committed his offense and when he pled, Mr. Mackey was shot in the head and almost died. That affected his brain functioning. He had a TBI and went through competency and was competent to stand trial. In regards to this being a second MTR, the state waived the first MTR, so it's not really something that the court, we believe, should consider. And we asked the court to reconsider that true finding. And the reason we asked that, Judge, is if you review those conditions of probation that are in the court's file, I've never had a contested MTR in which the state didn't either have the probation officer who read him those conditions testify that he signed those conditions, or number two, have someone, a fingerprint examiner, come in and testify that that thumbprint matches Mr. Mackey's thumbprint. The state has failed to prove that Mr. Mackey signed those conditions of probation, that he had knowledge of those conditions of probation, and therefore nothing could be found true because they haven't proved that he is the person who signed these conditions. In addition, what I testified to earlier and what Ms. Fuentes testified to was that there was no testimony or evidence presented by the state that Mr. Mackey knew to report to probation. There's nothing in those conditions that say, if this case gets transferred back to Bexar County, you must report to Bexar County probation. All it says is condition number 5 is report as directed to Bexar County. Well, we know that wasn't an actual condition of Mr. Mackey because he lived in Harris County. He was reporting to Harris County this entire time. Now, if the court still finds that it's true that he violated condition number 5, the court can do so, and we respect that. But we ask the court to review the totality of the case and that they have proven that he failed to report for 1 month out of 120 months. That's 0.8% of the time that they allege that he failed to report. And we ask that you consider what they've alleged and what they've proven and deny the MTR and release Mr. Mackey from this probation.
All right, the court is, as previously stated, the court is finding 5 true, 1 not true, 15 FF not true. The court will find the defendant guilty, grant the motion, revoke. There's an affirmative finding of deadly weapon. And I don't.
The admonishment may be in the second, which I can find it in this file.
Oh, the clerk printed it out. I couldn't find it either. I'm trying to see because I'm not the one who did the plea. The previous.
Are you looking for the plea bargain number?
I have the plea bargain, but there are no mention of no contact, or I'm sorry, there are no mentions of any no contact orders. So
I have.
I'm sorry, counsel, do you have the trial court certification?
I haven't had him sign it yet, Judge. I need to explain to him.
Want to see?
Yes, please. Okay. All right, there should be no contact. There's to be no residing in any households with minors. And the court will sentence you to 6 years in the prison, give you credit for any time served. Is there anything else?
We ask for findings and fact and conclusions of law.
And have you gone over the trial court certification?
I have not, because
All right, if you'll go,
he needs time to understand it.
yes, okay. And then just come back and I'll finish. Have parties announced.
Lauren Espinoza for the state.
Martin Getter, attorney for Naomi Alba.
And are you Miss Alba?
Yes, ma'am.
And defense, there was something you wanted to place on the record?
Yes, Your Honor, if I may ask for a few questions.
Yes.
Ms. Alba, are you the same Naomi Alba that's currently on a 3-year parole?
Yes, sir.
And you understand that by entering a plea today, that could result in your parole being revoked?
Yes, sir.
Knowing that the parole could be revoked, do you still wish to enter a plea today on this case?
Yes, sir.
No other questions.
All right, counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Alba, did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, state moves to waive the repeated drinking incident.
Any objection?
No objection.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Do you understand you're charged with possession of a deadly weapon in a penal institution as a third-degree felony? The range of punishment is anywhere from 2 to 10 years in the prison and up to $10,000 fine.
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. Did you understand by entering this plea, you're giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Alba, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
By entering this plea, if you're not a U.S. citizen, you will be deported, denied naturalization, and re-entry into the United States. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 5 years in the prison. There's a $1,500 fine. State opposes your application for deferred adjudication. State recommends community supervision. They will take in consideration 2025 CC 009259. Did you understand that to be your plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 5 years. There be a TAP evaluation and 200 hours of community service restitution. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charge, how do you plead?
No contest.
State, any evidence?
Yes, Your Honor. State offers State's Exhibit 1 and all attachments.
No objection.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses? The state would call in the right to remain silent.
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same.
Then we want to go forward. I don't know if you want to wait that long.
Yes, sir.
All right, then you're waiving PSI?
We'll wait PSI, Your Honor.
All right, the court will hear arguments against deferred?
Yes, Your Honor, state would urge that you deny the application for deferred based on criminal history. The most recent being an injury to an elderly person with bodily injury of January 9th, 2024, as well as multiple criminal trespasses, possession of marijuana, as well as evading arrest or detention. So that we don't see that she's fit for deferred at this time.
All right, and defense, your argument for deferred?
Your Honor, aside from the fact that my client accepts responsibility, I think there are some genuine issues here that make this different from the typical case of someone taking a deadly weapon into a penal institution.
Mhm.
In this particular instance, what we have is that the officers brought her there, and then we have CERT officers taking her further into the facility. Yesterday, prosecutor was kind enough to help me get additional questions answered regarding the video inside the Sally Port and also inside the South Tower, because there's unfortunately not audio that's available, it's only video. But this is not a situation where she is a person who is intentionally trying to sneak a weapon into the facility. And in fact, she indicates that later on to the investigator from the sheriff's office when she was interviewed. Your Honor, this is, again, I have no problem asking for deferred adjudication in this particular case because if you look at the criminal history, it's all relatively minor. There is that one injury to elderly, and I will say that the knife that was seized was actually given to her from the person who was the subject of that previous injury to elderly case. She knows him, she's worked with him. He gave her that knife because he was concerned about her own safety because she walks quite a bit and she does so at night. And so again, this was something that was for her own protection. I just think that there's much to distinguish this from the typical case and that she does not pose a danger to the community and her relatively minor criminal history. I think all weigh in favor of her getting deferred adjudication, Your Honor.
All right, why didn't you just leave when he said he no longer wanted you there?
Ma'am, actually, he didn't tell me that himself. It was just the neighbor that actually, I'm not sure the word, but he was kind of meddling into our business. I was there to cut the old man's toenails, as a matter of fact.
Mhm.
And I had fallen asleep on the couch, and the neighbor came in and he was meddling in our business, and he just started yelling at me. And then instead of, yelling back at him, I just sat back down and I just kind of dozed off into my sleep. But the old
But no,
man,
they talked to the person there and he said he wanted you to leave and you wouldn't leave.
he never told me that, not once, ma'am.
Okay. So do you have any children?
Yes, ma'am.
And how old are they?
5 and 6 years old, ma'am.
And who do they stay with?
Their father.
When's the last time you had employment?
Well, I was self-employed, basically just working for that old man.
Okay. All right, this is what the court is going to do. The court is going to find you guilty. The court will sentence you to 5 years in the prison, suspended and probated for 5 years. There's a $1,500 fine that will be probated. Take in consideration 2025 CC 009259. There's to be no contact with Jurgen Smith, JUERGEN SHMIDT. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days of release, no employment as a home health care provider or with minors, field visits 1 time per month until further notice, no unsupervised contact with minors, no residing in households with minors, 200 hours of community service restitution. The court will order parenting classes. Once that's completed, the community service hours will be deemed satisfied. Probation, is there anything else?
Okay.
Is there anything else that you need from the court to be successful?
No, ma'am.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal? With your attorney, did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, sir.
All right, good luck to you.
Thank you.
Thank you.
You have a good day. God
Oh,
bless
thank you. God bless you too. You're
you. I
welcome.
like your joke earlier.
Okay. And if you can give a reset form to Mr. Keating. Now, the next issue is the motion to set bond. He is on deferred adjudication, so he is still entitled to a bond. Is there an agreement on the bond amount?
I don't believe there's an agreement, Your Honor, but the state would be asking for a $60,000 bond.
All right, and defense, what are you requesting?
I would request $10,000, Your Honor.
All right, defense, do you have any witnesses?
We have no witnesses. I would, for the limited purpose of this hearing, call Mr. Keating.
All right. Can you raise your right hand to the best of your ability? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Michael Keating,
All right, defense, you may proceed.
Mr. Keating, where do you reside?
Greenville.
It's correct that you also have a second residence in Cami County, is that correct?
Yes, sir.
And the court has previously ordered that you would be allowed to reside at both houses?
That's correct.
Okay. You work,
Travel, yes, sir.
but you're based here in San Antonio.
Yes, sir.
You have extensive connections to San Antonio.
Yes, sir.
Does this court have any concern whatsoever that you might not appear on the 20th as directed?
No, sir.
I have nothing further from Mr. Keating.
All right, so there was a question asked that I have allowed him to reside in any place other than Bexar County and Cami County. Is there some documentation of that?
I don't believe, just for clarification, I was only trying to establish that he has two houses and the court has previously allowed that he would be able to stay at either house. That's Cami County and Bexar County, nowhere else.
I mean, is there some document probation?
I believe it's in the court record, actually, Your Honor. That's where I read it on Odyssey.
I'm gonna need the file on that.
Yes, ma'am.
Did I allow Mr. Keating to reside in Bexar County and Cami County? And I just need the docket sheet.
Yes, ma'am.
Any questions, state?
Mr. Keating, do you ever travel outside the state for work?
Yes, ma'am.
Do you get permission from the court prior to doing that?
I did obtain that, yes, ma'am.
Thank you. No further questions.
Judge,
Yes.
you gave him permission to travel within the United States and internationally for work purposes only and have a secondary address.
Your Honor, if I may though, that secondary address on the order amending conditions was in Guadalupe County.
All right. And you're requesting 10,000, you're requesting 60,000? All right, Mr. Keating, has there been any mental health issues in the past with you?
No, ma'am.
Have you ever been on any type of medications for mental health issues? Has there been any drug use in the past? All right. This is what the court is going to do. The court is going to set the bond at $20,000. The court is going to request partial GPS for employment only. Waive GPS fees. All right, is there anything else?
Just for clarification, so he'll GPS, but he's able to go to work.
Yes.
Thank you, Your Honor.
All right. Once you sign the reset form, counsel, and if you'll let your client sign the reset form, is there anything else?
Nothing from us, Your Honor.
All right, the record is closed.
Thank you.
All right. Mr. Montia, we're going to recall you back, and we're going to recall you back late January. And the reason being is because you have a scheduled appointment in the criminal magistrate's court. So we're going to call you back on January 19th.
Yeah, but ma'am, I have this paper, this is what I've been arrested for. And y'all got me for 36 arrests,
Mhm.
and I've been booked for this. through Connie, lawyer never even came to see me.
Okay.
It's
All right,
here's
Mr.
harassment of her public servant,
Mhm.
and it says inmate death of property of conviction.
Oh, no, that's fine. All right, so Mr. Manita, let me explain something to you. So before anybody can proceed forward with my answering your questions about your cases, the first thing you'll have to see a doctor. And I'm going to see if they can expedite you before January 9th, but so far you're set for January 9th. And the reason why there's a gap in your setting is because we have a shortage of doctors who are available to interview. But I'll see if they can make it happen sooner rather than later. But we're going to bring you back here on January 19th. However, this is your attorney. And if everything is completed before then, your attorney will come in and we'll put you on the docket as soon as possible, okay? All right,
Thank you, Your Honor.
Thank you.
What I'm seeing is why am I being, what is my case for?
Oh, so you're charged, just one moment, I'll be able to tell you, okay? Just give me a second. You're charged with harassment of a public servant.
And he's got a misdemeanor, Your
And
Honor.
you also have a case that is not in this court. So those are issues that have to be addressed after January 6th, okay?
Thank you
All right,
very much.
thank you.
I was nervous and I went to the courthouse.
We're gonna be ready.
What's this?
I mean, but you've been here before.
Yes, ma'am.
So this is a motion to withdraw,
Beverly.
and why? What's going on?
The only allegations are a new number 1 and a number 2 out of another county. And Lauren reached out to the other county to see if we could get anywhere on possibly trying to prove that up, and she was unsuccessful. Given that we've made an agreement to withdraw and alter and amend with some additional conditions,
And what are these conditions?
to have him submit to IOP, supportive outpatient treatment, and monthly UAs based on the TAP evaluation and sober support meetings. In addition to a no contact order with an individual named Raul Sanchez, who was the person he was with when he picked up the new case in Victoria County.
All right, let's go on the record. The court is calling 2021 CR 4317, State versus Kevin Ray Lawwill. Can I have parties announced?
Melissa Albin for the state.
Tilden Schaefer from Mr. Law.
And are you Mr. Lawwill?
Yes, ma'am.
All right, state, you filed a motion to withdraw, and it's the court's understanding that there is an issue with allegations that are in the motion from out of county,
That's correct, Your Honor.
and that the contact persons from out of county have no plans to appear.
Yes, that's correct, Your Honor. We've made attempts to reach out to them, but been unsuccessful.
And then, but to address those issues, and it's the court's understanding, the defense, you've agreed for the motion to be withdrawn, and in exchange for that withdrawal, you're requesting what?
We are requesting to alter and amend his conditions to include sober support meetings, monthly UAs, IOP, and a no contact order with an individual named Raul Sanchez.
That is correct, Your Honor.
All right. And Mr. Lawwell, can you raise your right hand for me? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Kevin Lawwell.
All right, Mr. Lawwell, do you understand the new conditions that are being added to your probation?
Yes, ma'am.
All right, and you intend to follow those conditions?
Yes, ma'am.
And so you're in agreement with IOP, the sober support meetings, monthly UAs, and no contact with Raul Sanchez?
Yes, ma'am.
All right, we can go off the record.
Judge, just so it's clear, I did explain what IOP is, it's intensive outpatient, so
Yes.
he knows what that means.
All right, thank you. All right, so Mr. Lawwell, you are on probation. And it's regular probation?
That's a good question, Judge. I believe it is.
All
Yep.
right.
Yes, yes, sir. No, you're lost out.
Is it?
No, it's deferred still. It's still deferred. Sorry, it is deferred.
So here's the thing. This is what you have to realize. You're on probation for deferred adjudication. What you're on probation for is a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison. Everything that you do, the people that you associate with, if those are people who are, for want of a better word, sort of shady, you shouldn't hang out with them because you'll pick up a motion to revoke. And you're looking at potentially 20 years in the prison. Do you understand?
Yes, ma'am.
All right, good luck to you. Once you sign the conditions, you're excused.
Thank you.
Thank you.
Might be excused.
You too. Court is calling 2025 CR 010462, State versus Cami Lumpkins. Can I have parties announced?
Megan Galley for the state.
James Tochi for Ms. Lumpkins, Judge.
And are you Ms. Lumpkins?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Ms. Lumpkins, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Ms. Lumpkins, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with possession of a controlled substance, penalty group 1, less than 1 gram. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Do you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
No contest, Your Honor.
No. My question is, did you intend to give up those rights that I've just mentioned to you? Do you understand those rights?
Yes, ma'am.
Are you asking the court to allow you to enter into a plea bargain agreement with the state?
Yes.
Did you understand that the court were to grant your application for deferred adjudication? If for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine.
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, ma'am.
Ms. Lumpkins, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering into this plea bargain agreement, you will be deported, denied re-entry and naturalization. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's a $1,000 fine. State recommends deferred adjudication. They will take in consideration 2025 PF 25148, 2025 AL 006849. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Judge.
State.
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, ma'am.
Outside the agreement, the state is requesting that your deferred adjudication be for a term of 3 years. There be a TAP evaluation, 100 hours of community service restitution, no contact with Xiomara
Perales.
Xiomara Perales, life skills course, parenting classes, and prohibited possession of firearms. Did you understand those were recommendations from the state?
Yes,
And
ma'am.
the court does not have to follow those recommendations.
Yes, ma'am.
Then to the offenses charged, how do you plead?
No contest.
State, any evidence?
Favor for states one and attachments.
Thank you. State, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses? The state would call in the right to remain silent.
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, ma'am.
Anything you wish to say on behalf of your client?
Just a couple things, obviously, that the court follow the agreement. I don't believe Ms. Lumpkins has any history prior to this. She does have a minor dependent, Judge. I know that there's a fine, and I should have mentioned this earlier. She's not employed. She does care for the 3-year-old dependent. You could perhaps help her with her fine. And she took a parenting class already while in custody. Just wanted to make you aware of that.
All right. So you have a 3-year-old dependent?
Yes, ma'am, but
And if-
I signed over my temporary rights to my mother as well.
And it's, I'm assuming Child Protective Services is involved?
They were involved, but they closed the case as soon as I signed over the rest of my mother.
All right. So I'm telling you all, what's the child's name?
Roman Lumpkins, RHOMEN LUMPKINS. And his middle name is Connor, CONNER.
So it's Roman Connor Lumpkins? All right, so it appears to the court that the only reason why Child Protective Services is not in her life is because she signed over rights to her mom.
Yes.
So I'm not gonna do this thing where you signed over your rights to your mom and then you go back and say, let me take my child back. Oh, well, I'm gonna make sure that doesn't happen with conditions. So when's the last time you had employment?
The last time I had employment was about 6 months before I got incarcerated. I was donating plasma to help keeping my benefits and as well as giving my son clothes and shoes that he needs.
All right, what benefits?
EBT and Medicaid for him.
All right, so then you didn't have employment. What was your employment?
I let them know that I was just donating plasma and I would get $60 to $75.
Okay, that's technically that's not employment. So when's the last time?
6 months before I got incarcerated.
Doing
So
what?
I was working at Babes Old Fashions restaurant.
Okay. I always see that restaurant. I've never gone in and tried it because usually I'm passing by.
Kids eat free.
Yes, they do.
Oh, so you've been, okay.
Yes.
Well, let me bring out my pigtails. Going to school.
I only went to 10th grade.
All right, why?
I was never really involved with school. I was always just running around doing a little with them. Instead of doing education, I was just running them off.
So what are your plans? Because you have a child.
My plan is to get a GED and show him that his mom can turn around her mistakes and better herself.
All right, so you're gonna have to reside somewhere other than your mom's.
I don't have anywhere else.
Well, here's the thing, I'm not, at this point in time, I can't trust you with your child at this point in time. I mean, it's a no-go for the court. This is what the court is gonna do. There's $1,000 fine. That will be probated. Court will sentence you to 4 years deferred adjudication. There's to be 100 hours of community service restitution. Ms. Abrams, the parenting classes at the jail is not going to count towards her parenting classes. Once parenting classes are completed, 50 hours will be deemed satisfied. The other 50 hours will be deemed satisfied if she obtains her GED. If for some reason you're unable to obtain your GED, then you're going to have to do those 50 hours. There's to be regular reporting by Zoom or in person. There's to be regular random UAs. There's to be no unsupervised contact with minors. There's to be no residing in household with minors. There's to be no contact with Xiomara Perales. Course. Take into consideration 2025 PF 25148. 2025 AL 006849. The following will be done in custody. There should be a referral to felony drug court and a TAP evaluation. If not accepted in felony drug court, then follow TAP recommendations and field visits 1 time per month until further notice, or that can change if she's accepted in felony drug court because they will do their own field visits. I'm sorry, what?
How many months of field visits?
Until further notice. All right, Ms. Abrams, is there anything else? Oh, thank you. There's to be proof of employment within 45 days of release. There's to be no employment as a home health care provider or with minors. And what I can tell you, because you don't have custody of your child is not with you, so those benefits should stop for you.
Yes, ma'am.
Did you read the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. We can go off the record. Here's the thing. That 3-year-old can't even fend for themselves. That 3-year-old is 100% dependent upon you. And what did you do? You drove in a vehicle that was stolen with this Perez person. And then not only that, you all are doing drugs in the car. There's drugs in the car. And let me just tell you, meth stinks to high heaven. We had a case in this courtroom where someone brought in meth, and it took us forever to get that sent out of the courtroom. And you driving around with a 3-year-old impacting their brain cells with meth and marijuana in the car.
In my defense, she didn't let me know that the car was stolen.
Here's the thing, there's no defense. There's no defense to driving around in a vehicle. And let's say you didn't know it was stolen. You had meth in your bag. She's driving away with drugs. You can't tell me that you don't know the people you hang around with. How long had you known her?
On and off for 8 years.
All right, so you've known her for 8 years. So number one, you know what type of person she is. You've known her for 8 years. And if you were to tell me it was a complete stranger, then I would be asking you, why are you getting in a vehicle with a complete stranger when you have a 3-year-old? If you want to put your life at risk, then go for it. But you're putting that child's life at risk by doing that. And signing over your rights to your mom, I already know that's the easy way out. And what ends up happening, people are in CPS court, and you know what they do? They sign their rights over to a relative. CPS gets out of their life, and then guess what they do? They go back to that relative, and then they have that child again. 5, 6, 8. Can I have parties announced for the record for the state?
Melissa Albin for the state.
James Seeloff for the defense.
And I'm so sorry. The style of the case is the state versus Beverly Marie Zuniga. And are you Beverly Marie Zuniga?
Yes, ma'am.
Did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes.
Are you the same Beverly Marie Zuniga who was placed on community supervision in 2022 CR 2568 for the offense of assault family second offense on April 14th, 2022 for a term of 5 years? Is that you?
Yes.
All right, state.
We're going to proceed on number 38, Your Honor. In Bexar County, Texas, the defendant Beverly Marie Zuniga did then and there fail to report weekly for a period of 3 months as directed in violation of condition number 38.
How do you plead to that? True or not true?
True, Your Honor.
We'll waive the rest, Your Honor.
Any objections to the waiver?
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 38, the court could find it true, grant the motion, sentence you to 5 years in the prison and a $1,500 fine? Knowing that, do you still wish to plead true to violation of condition 38?
Yes.
Court will find violation of condition number 38 true. Is there a proposed agreement?
There is not, Your Honor. I
We're
believe
going to open.
we are recommending revocation, and the defense would like to ask for something else.
All right, defense.
If the court is going to revoke, we ask the court to do less than 5 years. She's currently taking medication for a heroin problem. And apparently she's doing quite well on that. She's got a couple of children, the youngest being 17. So I asked the court for a little mercy in this matter, and asked for credit for time served also.
All right. So probation, what has she done?
Your Honor, can we have just a few
moments to step back and review the court summary?
Sure.
Thank you so much, Judge.
They would just let me do their part.
Yeah, it'll take them probably 2 minutes to review this.
Now he's here. Yeah.
We're not on record yet, so that we don't have it yet. That's good. Please step forward to the mic. This is
That's mine.
Hey.
You know how we do this, and we're gonna do this one. We already played through this one. Wait for rest. Where's the rest of
Judge, I'm ready.
All right. So defense, what are you requesting? Are y'all ready to proceed or no?
Oh, Your Honor, we seem to have misplaced the court summary. Thank you, Judge.
Sure. All right, so defense, it's my understanding from the state, they're recommending revocation. What are you requesting?
I'm asking you to. Pardon?
The state's recommendation is to revoke and sentence for 5 years, TDC.
All right, and so what are you requesting?
I'm requesting less time than 5 years, 2 to 5. I'm asking, and I want to point out that she's 40 years old. She's taking a drug right now, a prescription drug to help with her heroin. And she's doing very good on that. She has a couple of kids, the youngest being 17. And I asked the court for mercy.
All right, so is there anything you wish to say to the court?
If given the chance, would you go for?
Well, if she wants to say anything,
Okay.
then she'll need to be sworn in.
Okay.
Oh, yeah, I was saying.
You want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand, state your name for the record.
Beverly Zuniga.
All right, and probation, she has pled true to violation of condition number 32. I'm sorry, 38, and the
30.
court has found that true. All right, what would you like to say?
I was letting my lawyer know that I was likely to get my GED because I didn't finish high school. And also my grandmother, she like relied on me. She has a pacemaker in her heart. She's 87 years old. I don't have my parents. They passed away when I was very young. She's my only
So let me ask you this. If your grandmother is relying on you, why would you come to me? And this is your third motion to revoke. And let me just remind you, your first motion to revoke was a violation of condition number 2.
Yes.
The court denied the motion, alternate in conditions to get you drug treatment. Then your next violation was a violation of number 4. The court alternate amended your conditions and continued you. And now you're back here for another motion to revoke. So why were you not thinking of your grandmother needing you before?
No, I have been, but I recently I had a stroke myself, and as you can see, my right hand is stayed messed up, and I have this on my eye from when I fell. This happened in October. It's been like trying to take care of myself and take care of my grandmother. It's been really hard, and then with my kids, my daughter, she has lupus, the 17-year-old. She's in college. She just finished school. She doesn't have a father. She just has me.
All right. So this is what the court is going to do. The court is finding violation of condition number 38 true. The court is going to grant the motion. There should be no contact with Paula Pena. There's an affirmative finding of family violence. The court will give you credit for any time served, credit for any time served in inpatient treatment, and the court will sentence you to 5 years in the prison. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it? All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are in community supervision. Because this is a felony conviction and an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, good luck to you. Thank you, Counselor. Who else?
Thank you.